pensions are valued in a different sense than other assets because it's not clear as to their values at specific dates, that we cannot just use our normal bank statements or other disclosure that we can get from our financial institutions. There is a valuation process done either under the Pension Benefits Act on a provincial level or under the federal legislation as well. As of 2012 in Ontario, there is a specific valuation process that we do under the Family Service Commissioners of Ontario forms, whereby the pension administrator will value from the date of marriage to separation the increase that we could use in our cases as the exact value for purposes of property division. It very much matters whether the pension that we are dealing with is regulated by the provincial legislation or the federal legislation. Why? Well, normally the valuation process is quite similar. However, what each party is entitled to as a spouse and how it could be divided often is different, whether it is federally or provincially regulated. Sometimes our job is involved being pension specialists, which we are not. So often we do have to meet, and part of our team here at Nathens Siegel is certain valuators and appraisals that we deal with to know whether it's federally or provincially regulated and what the differences are as far as how we can implement and best advise our clients. Well, the survivor benefit is a calculation based on what type of pension it is of the amount that the non-retired spouse would obtain should the retired spouse pass away prior to obtaining their full benefit entitlement. So the question as to whether it does need to be valued or not is all dependent on the situation at the date of the retirement of the pensioner. If the parties are still married, then yes, the non-member spouse needs to have a valuation of that amount of an asset, because whether they are separated or not down the road, they would still be entitled to that amount. So it needs to be valued as his or her property for equalization purposes. When we look to secure obligations or potentially obtain a piece of someone else's asset that is governed by the Pension Benefit Act, in family law orders we make provisions as to who is going to get what. And often we must know how those mechanisms or financial beings are regulated, because maybe something we would like to do in an agreement or a court order won't be carried out the way we intended it to, because the Pension Benefit Act has its own mechanisms or own rules which will override the Family Law Act, unfortunately. It's very important when dealing with complex financial situations to know what source of asset you're dealing with, what can or cannot be done, if there are other former spouses that have entitlements that can affect what you're trying to do. So really just be very careful and talk to pension and estate experts when dealing with complex transfers of property.